Imagine you buy a piece of land, pay full price and get it registered. And few years later, you will receive a notice stating the sale is illegal as well as void and it has to be restored back to the original owner without being compensated sometimes. And this situation is very real when it comes to matter of lands of scheduled caste as well as the scheduled tribe. The foundation of these laws lies in the following constitutional provision. Article 15, Clause 4 empowers state to make special provision for scheduled caste as well as the scheduled tribe. Article 46 directs state to protect them from economic as well as social injustice. And Article 300A recognizes right to property subjected to reasonable restriction by the state in the interest of social justice. Based on these principles, almost every state has enacted special laws for the SC/ST lands. The core principle or the core rule is simple. SC/ST land cannot be sold to the non-SC/ST person without the prior permission of competent authority. And if any sale is done, it has to be held as a void from the very beginning, irrespective of the payment, registration and the passage of time. And it has to be restored back to the original owner. However, there are certain exceptional cases where under certain circumstances the sale is valid but only with the prior permission of the competent authority. Further, the sale between the same communities is valid and no restriction is imposed on them. And even the courts has consistently upheld these provisions, emphasizing that for SC/ST communities, land is not just a property, it's a livelihood, dignity and security. And these laws enables them to undo the historical injustice as well as renewed economic exploitation. So, my question to you all is that whether this restriction is equally applicable to the government during the land acquisition? Let me know your answers in the comment box. Thank you.